Okay, hello everybody. I think we experienced some technical glitch right at the beginning. The reel that I wanted to share does not play the music; it plays the AI pictures that I created. So we'll fix it. Maybe it will actually help with the with the copyright issues that we are facing always. But so I took it down. Please take a look in my reels. I see people are joining, so welcome everyone. That's another episode of the TRoman show. My trusted co-host, Timothy Phillips, all the way from Las Vegas, Nevada. And we have one of the best, hello, one of the best, he told me not to flatter him, but I will, one of the best pro se litigants in, certainly in the state of Colorado, I think also in the US. We can qualify continental US, right? but certainly one of the most well spoken, well written, eloquent pro se victims of the court, Rabbi Jacob Bellinsky, with an update from of this case. The topic for today's show that we want to start off is the emotional toll or the emotional aspect of getting an email from the court, a letter from the court, and how people react and what should we do. So, TMP, that was your topic, so please take it from here.
Well, this is to the viewers, at home that are watching this here. Um, I think it's so important to talk to other parents who are in the midst of the family court holocaust here, who have cases ongoing in family court, and I'm very fortunate to be able to speak with my partner Roman, who of course is a very wise and educated man, and also very humanistic and just I'm really very lucky to be able to talk to him. And an issue that had come up, we talk all the time, and we're both comparing notes, right? And it comes up the topic of this fear and apprehension that family court parents feel when they go to open a court order. You may get an email notification that there's a court order filed into your case, or it may be you receive a letter. But it seems to be, I've talked to friends and other parents in family court, and the same phenomenon happens over and over where you get the court order and you're afraid to open it, and there's a sense of fear, anxiety, and dread, and it's really overwhelming. And I'm a professional. I consider myself a professional. So is Roman, and yet I've opened so many court orders and so many letters and so forth from the court. I've had so many email correspondences, and in all my career, I've never been upset or emotional or having my heart beat or my palms of my hands sweating or a sense of terror and imminent, catastrophe about to happen. But it seems that it's always goes down whenever there's a new court order. And so we tried to ask, we're talking amongst ourselves, why is this? From where does this originate? And why should we have such a sense of panic and dread when it comes to opening a court order? And, at least from where I'm sitting over here, it seems the reason is because of the great unknown. And, the only thing we have to fear is, the unknown. That's the biggest fear. And when you get that court order, it's like you don't know what's going to happen. How are they going to cheat you now? How are they going to screw you over? What kind of thing did you not anticipate that's going to come entirely out of left field and entirely shatter your life? And so what I just wanted to say to the viewers is that you are not alone in feeling this, because everybody senses the same kind of panic and upset when it comes time to confronting a court order. I mean, I've had other parents call me and say, "Hey, I'm about to open a court order. Would you hold my hand, metaphorically speaking, while we're on the phone, and or read through it with me?" And I think this again, it's just because family court is so unpredictable and so chaotic and so crisis driven and so unexpected, where they make up things out of nowhere. It seems just to disorient and keep one off guard. But without going on too much about this, I wanted to hear from the both of y'all on this topic and maybe hear what the viewers have to say. But I'm just hoping that people will realize it's important to stay grounded and stay focused and confront the court order or whatever it is that they and deal with it as it comes up. And just know that I think it's part of their playbook. I really do think the family court has perfected this in such a way to instill in the parents that sense of fear and anxiety by coming up with crazy things that you never expected in a court order. And so I would just, if I could give any not legal advice but practical advice, I would tell folks to stay grounded, stay centered, and and that kind of thing. So, what do you gentlemen think?
I agree respectfully, and it's actually very curious, very interesting that you brought the topic because it shows how prevalent, how universal it is. I have my own thoughts. I completely agree with you. I think it's part of the playbook. We saw it on a mass scale, on the macro level, and also on the micro level, because the easiest enemy to defeat is a demoralized enemy, right? And we are essentially, unfortunately, in a psyop war waged against the population by the governments. It's a psychological operation on every level. So if they drive you to desperation, they drive you to depression, God forbid, right? And the sense of dread that you described, then you're less likely to push back, less likely to make it public, and that's what they want. They essentially, in a sense, metaphorically speaking, they feed off the sensation of fear, and that's what the government, the system is trying to instill in the people. We see it in many levels. I always like to connect it to the bigger picture, but we now see that in Canada, for example, the voluntary end of life, right? All this euthanasia, bills, right, being propagated here in New York. It gets a prominent stage. Why they do that? Because people are depressed. Okay, so that's an easy solution. Just get out of this life altogether, and they will assist you and support you. It's insanity, but it all stems from the same source. Same source. These people are very proficient psychological operators. They know, they understand the mass psychology, right, and human psychology much better than humans themselves. So yeah, that's universally shared. It's on purpose. It's done all the time. They feel literally. My comparison is like you go into court, you don't know whether they will cut your arm, cut your leg, what will happen, and the sense of fear that you're describing. I also, in my practice, right, you open a civil decision, or that's a civil court. You never experience something like that, but why do you experience in family court? Because what they do, right, essentially they take the most important thing, your children, right, and that's something that of course we're all too familiar with. Jacob is disconnected. I know he's out there in a suburban area, so we have some connectivity issues. But when he comes back, I'll of course pass the mic to him. I want to acknowledge the viewers. So John, a loyal follower, friend here from New York. Maybe John will join at some point as a guest as well, saying hello. I see that Orlando Marquez, narrative warfare. Excellent. That's an excellent observation. Yes, and we have more people actually joining and viewing. Please post comments. We'll have a discussion. It's a free form conversation. Here he is. So Jacob, can you hear us? Are you connected?
I can't.
You kind of okay.
We can see Jacob, but
we can see. We can hear you. So
now I can hear you.
Okay.
I came outside. I missed the last few seconds, but you want me to comment briefly on what we were talking about?
Yes. Let's that's a topic we wanted to start, and then we would like to. I think everybody would like to hear your update, because last time we talked, we were about to go into sentencing. So go on. Thank you.
Yeah. So I agree with what you were both discussing as far as this feeling of dread. I think what really it's all about is, Roman, you actually said it. I think you said it best. You said that it's like you're facing the enemy, or it's a psychological war. Well, when you get an email from the court, you're basically trying to see what's the what's the next move? Like you said, are they going to cut my arm off, my leg off? What are they going to do next? But I think it goes deeper than that. They also just want you to surrender. They want you to give up. They want you to give in. They want to deprive you of any resolution. I mean, in many cases have gone on. I never could have imagined cases going on for 10 years, 15 years, 20 years. My case is essentially or effectively been going on for 5 years, and this post-decree stuff, it's deeper. That is almost impossible to win. Are you there?
Yeah, you're
Yes.
coming
You
in
hear
and
me?
out, but we can hear you, even though we've been yeah. We are listening. So I want to acknowledge Christina is also
Okay.
online. So John, Orlando, Christina, thank you very much, everybody. Please share if you see it. Please comment. Let's make it an interactive discussion. And everybody's welcome on the next episode. Yes, Jacob.
And if I could add one more thing too, it's not just opening the court orders that brings a sense of fear and panic and dread, but it's also the idea of going to court. And I was thinking, and of course Roman and I were talking about this on the phone, but I must have thousands of hours literally of courtroom experience. And when I was young, when I was first coming up, I would be maybe nervous approaching the lectern and addressing a judge, but it's pretty much second nature now. And yet, when I go into the family court, I was last there, I think in August of last year, and I was a nervous wreck going into the court. And it's only because you have no idea what kind of shenanigans, what kind of trick, what kind of, something out of left field to completely, demoralize and to take you off guard. And whether it's the opponent filing something at the last minute or there's always something chaotic. And I have to think that that's done intentionally. And of course, I think the reason is, Roman, you really hit the nail on the head. It's to demoralize. And by demoralizing us, it's easier to control, easier for them to run roughshod all over us. But I would like to tell people, stand tall and remain resolute and remain in present time, so to speak. And I would also say to the viewers at home, if anybody is about to open a court order and they're feeling that sense of internal panic and dread, please call me, and I'm happy to, babysit, as it were, and hold your hand metaphorically on the phone and open it and go through the order together and read it calmly and try to absorb it. Because I think what happens too is when people open the court order, they just skim it. They're so nervous they can't really read and process the data in a kind of clear, concise fashion. And so I think it's important always to read your court orders, just because you want, it's obviously, but I've noticed many people, including myself, will miss things because we're so burdened with that sense of panic and dread and anxiety that goes with, receiving a court order. So those were my thoughts, and the offer stands. Again, if anybody wants to contact me, I'm always happy to reach out. So
yeah,
there it is.
No, thank you. That's very generous on your part, and it's important for people to understand that you are here. Of course, once an attorney is always an attorney, probably, right? There's no, as they say, there are no former KGB agents, right? So. To differentiate, right, on the good side, you didn't join the evil side, but you also, unfortunately, you're a victim of the court. You understand the system, as your own title says here. You are not only esquire, also dispossessed father. So yeah, when you were describing that, I remember my own experience, of course, as a victim, as somebody who suffers from the same tyranny. But I had actually a mother, a victim mother. Jacob is here again. We need to let him talk, in the brief moments that he's online. But she actually asked me to open the decision and to read it and then to report it back to her. So exactly hand-holding, virtual hand-holding that you described. Jacob, while we have you here, it says you're in 50 seconds break. So give us an update about your case, please. Talk about what's going on since we last talked. So.
Sure. I'm sorry. Apologize about the internet problems I'm having. Not having a landline is a little bit of a problem for me. But can you guys hear me? Okay.
Yes.
Okay.
Yes.
So thank you for having me on this time and the last time, and for your support and for everything you're doing, Roman and Team Matthew Phillips. It's an honor to be here with you guys. Basically, last time we left off, I was being sentenced fraudulently for a forward text message, have daughter call me. They essentially recommended 2 years of supervised probation, or they didn't recommend, they sentenced me to 2 years of supervised probation with as an act of domestic violence for a forward text message, have daughter call me, which was after the fact. They didn't have the jury decide on that, but the court stated that they had the right, according to a recent U.S. Supreme Court precedent, saying that it doesn't violate my Sixth Amendment right. But basically, they just decided that it was an act of domestic violence, so they sentenced me to 2 years of supervised probation, domestic violence evaluation, treatment, psychological testing, monthly or biweekly drug testing, classes, all kinds of things. I originally tried to stay the proceeding, or to stay the sentence, to stay the execution of sentence at the end of the sentence, but the judge refused and said that she's not going to review it right away, but I have to go straight to probation. So I went to probation. I had a couple of meetings with them, but I ended up filing. I ended up filing a formal motion for stay execution pending my appeal, and I filed an appeal, or a second appeal, because the first one was denied based on some jurisdictional issues. But they ended up staying the sentence temporarily while the appeal is pending. So everything got paused, which was, I think, a small success. So in the meantime, I don't have to do all this, all of these things. I'm trying to get the judgment I'm trying to get it overturned. And so that was a little bit of a success, I think. So in the meantime, I have this appeal pending. The first appeal I filed was from the district court to the appellate court, because they represented in all the paperwork that it was. I have this appeal pending. First appeal.
Some sort of echo. Maybe you're also in parallel watching. So no, they just appeared.
Oh.
Yeah.
Anyway, they originally represented the case as a district court case, not a county court case. And so when I appealed it to the appellate court, they basically said, we don't have jurisdiction. And I said, well, if I answer a rule to show cause and different things, in the end, the bottom line is they dismissed that. So I had to file an appeal from the county court to the district court. On a separate matter, I'm also in the middle of technically an appeal with the domestic relations case, the fraudulent domestic relations case that's been ongoing for 5 years, and that was opened fraudulently by my ex-wife 5 years ago. Anyway, both of the appeals I'm actually trying to do some extraordinary things inside of, because the case law and precedent says that you can't appeal a void judgment, and when there's fraud upon the court, fraud by the court, deprivations of rights, violations of rights, and crimes, and if they've been proven and they've not been refuted, then by operation of law, the judgments are void. Anyway, so to have the appellate courts review a void order is actually an unlawful act by the appellate court itself. That's from the Freytag versus Commissioner case, and there's other case law regarding that. But I'm basically telling them, hey, this appeal you have to dismiss, but before you dismiss it, please take judicial notice of the fact that these orders are void, and you need to set aside the orders for various reasons. So I have taken an approach, an unusual, extraordinary approach in these two appeals. I also filed a special motion to set aside the orders, but rather than have a three-judge panel like they normally do, or en banc for the entire appellate court to review it, they
essentially gave it to one of the corrupt district or one of the corrupt appellate judges, and he denied it immediately with a one line denial. Upon review of the motion, hereby deny your motion. That's basically, and I've filed probably 4 or 5 petitions at the Colorado Supreme Court. I've dealt with the appellate courts, and they never give you findings of fact or conclusions of law. They only provide you with a one line denial. They because they're courts of discretion, they act like they can just choose and pick and choose what they want to hear. So if they don't like what you have to say, and they know it's going to interfere with their racketeering, and it's going to expose their wrongdoing, they basically want to just get rid of you, and so they deny you with one line. On a separate note, if you would like to know a little bit about where my federal cases stand, I actually just filed a very scathing objection, 23 pages of objections with 3 attachments to the magistrate's recommendation to approve all the motions to dismiss in my federal cases. On the last show I was on, the one we talked about, Rooker-Feldman and Younger abstention, I did a tremendous amount of research and deep dive into all the recent case law in the 10th Circuit Court. And basically these federal judges are just ignoring, and trying to fraudulently, ignoring the reality of the facts of the cases. And they're just trying to dismiss it based on Younger and Younger abstention doctrine and Rooker-Feldman doctrine. Anyway, I filed a series of objections that should hopefully stir some things up. Basically they were improper in trying to recommend dismissal, a blatant dismissal, rather than doing any kind of a claim by claim analysis. I'm sure Matthew Phillips is very familiar. Matthew Phillips is familiar with how all this works, but they just said, "Oh, we don't have jurisdiction, so we don't want to hear anything. We're not going to analyze or review any other arguments that were brought forward." But for both cases, they did the same thing for me. I had 2 federal lawsuits. One was dismissed in the middle of April. The second one was dismissed May 1st. I filed objections in the first one, and I just filed yesterday, late last night, objections in the second one. But they essentially, allowed me to go on for 3-4 months in each case. Had to spend hundreds of hours answering these fraudulent motions to dismiss by district attorneys, state employees, the attorney, my ex-wife, or her fiance, basically, who adopted the state's arguments. But the thing that's really crazy about this, and I think you touched on it in one of your other cases, one of your other shows, Roman and Matthew, is that they are allowing the Attorney General's office to represent the state employees, and all of the defendants are joining in these joint motions to stay the proceedings, and they're all collaborating and conspiring together. So you have state funding. The Attorney General's office is funding an entire team of lawyers, an entire team of attorneys against little old me, pro se litigant, and they're basically bringing in all the private parties with them to try to basically destroy my case and get it dismissed. And the state is spending hundreds of thousands of dollars, resources, a team of attorneys. And I've asked them, I told them about the conflicts of interest. They need to hire a private attorney. They can't represent, when a state is a party in its own case, you can't, they can't also be a judge anyway, it's, so there's a lot going on in these cases, but I'm very happy and confident about what I just filed last night. I just posted it on my Facebook page. It's quite lengthy, but there's a lot of interesting case law with regards to Younger, Feldman, and Rooker abstention. And one of the things, like I told you, I think before in the last show, was that I only filed for monetary. I only asked for monetary relief, and I only asked for a federal court, district court judge to administer due process and to oversee the administration of due process and referee the trial by jury. What they did in the recommendation, though, is they fraudulently added the words, quote, in the state court at the end. So they were trying to suggest that I was asking them to interfere in a state court matter, which I wasn't, which is a major prong of the Younger abstention and also related to the Rooker-Feldman doctrines. And they also tried to connect my second case with a domestic relations case, which has nothing to do with it. So they made all these fraudulent, tried to make all these fraudulent statements and connections, but by simply adding 3 words in the or 4 words in the state court at the end of my words, they essentially completely changed the whole meaning of what I was asking for. Because I said I'm not asking the federal courts to do anything other than oversee the administration of due process and referee the trial by jury, period. But it was meant in the federal court, not in the state court. They added the words in the state court. But this is what courts and judges and magistrates do. They try to fit their case fixing to the precedent and case law that just doesn't simply apply. And so I had to spend dozens of hours responding and objecting to this fraudulent recommendation. Anyway, so that's kind of where my cases stand currently. I hope that was a good synopsis.
It was an excellent synopsis. So thank you very much for providing that. And I know that you post some of the filings online, right? You are getting more and more public. So thank you for doing that. And I'm particularly impressed, if I may say so, by your success in staying the sentence. It is an achievement. It is a great achievement. This is not a trivial thing. And I assume you filed for stay yourself, right? So to the extent you are comfortable with, please post, your motion and also the decision. I think it can help other people. And I know that your papers are always well researched, well written. So please do that. That's not a small feat to stay in execution, especially that's considered, in their eyes, somewhat a light sentence, right? This is not a trivial thing. So that's a great achievement, and it should encourage other pro se litigants to continue. Matthew, would you agree?
Absolutely. I'd like to say a few words about Rooker-Feldman, if I could, because I had another. It's so prevalent, and I talk to people all the time about Rooker-Feldman, and there's lots of case law on point. But if I could say one thing that I think is really central, at least to me, the most important aspect is the Rooker-Feldman is, of course, it's a way for the federal government to not hear your case. The Rooker-Feldman doctrine is a pretext to kick your case to the curb. Well, what triggers the Rooker-Feldman? What would make it apply? Well, there has to be a final judgment. Now, there's lots of other elements, but I wanted to focus only on the concept of final judgment. And I'm of the opinion that in family court, there is never a final judgment, because the only thing that happens in family court is there may be a disposition on custody or a disposition on the financial assets. There could be dispositions, but there's never a final judgment. The way I see the law, the term judgment would only ever apply in a civil context where one party is alleging wrongdoing and either that party proves the wrongdoing or they don't. Now, in family court, they're really not alleging wrongdoing. Now, I know there's always a domestic violence twist, but basically, when you're in family court, you're there to divvy up custodial time. You're there to divvy up, assets and things like that. And these things change. You can modify custody. You can modify an award of support. And therefore, there's never really a final judgment in the sense you'd have in a civil court where the trier of fact says that plaintiff, you failed to meet your burden, or you did meet your burden. But the point is, if the plaintiff proves or doesn't prove their case, that would result in a final judgment, meaning the plaintiff either did or didn't prove their case, didn't prove the wrongdoing. But there's really no wrongdoing alleged in family court. Again, it's simply to divvy up assets in custody time. So those folks who are just try to focus on the judgment. There is no final judgment in family court. That's my story, and I'm sticking to it. So
yeah, as always, Jacob, I'm not trying to mute you. I'm not the court. I just we're getting some feedback from a microphone, so I'll just I'll toggle you if you don't mind, and I think you can untoggle yourself from this platform. So I want to acknowledge the audience. We are getting great participation here, and a lot of people are watching. So thanks everyone. Brad joined. Brad is saying, referring to the earlier segment that we discussed, that it's war against us parents. All they care is about intimidating tactics and bullying us for their sick narcissistic control and power, violation of the civil rights under color of law. Of course, 42 U.S. Code 1983, which is always the topic. That's how we all sue. Orlando posted a very interesting, lengthy comment about the flight or flight mode. So apparently, Orlando, you have a lot of experience in that particular area. So people, please reach out if you want to join us. We'll be honored here. Catherine, I think you're from California, right? So we have a good representation here of the West Coast. The government is stomping all over parents, right? CPS is kidnapping kids for cash. They all are kidnapping kids for cash, whether directly or indirectly. It's Title 4D. It's just unbelievable. We know it's the machine, the incentive behind it. Federal government is funding this tyranny. ASFA, right? Title 4E and D. E is adoptions. D is child support matching, bribes. Christina with the poignant comment, as always, stay of execution. That's exactly right. So Jacob was able to obtain a stay of execution, but we are all in the various stages of the execution. I wanna comment, and that's what I apologize, but I was looking at my phone because I wanted to find the exact quote. There's a Supreme case, a United States Supreme Court case that I like to quote in my papers. It is Rita versus United States, 551 U.S. 338, on page 356. Okay, Rita versus United States. It's from 2007. So not to butcher the quote, but not to butcher it. I have it here. So judicial decision, that's what the United States Supreme Court says. Judicial decisions are reasoned decisions. Confidence in the judge's use of reason underlines the public trust in the judicial institution. A public statement of those reasons helps provide the public with the assurance that creates that trust. So I did my research. Maybe there's better case law to quote, but to me, and Jacob, that's exactly the point. I think we need to dedicate the whole program to that. But the fact that judges do not provide decisions to their orders, right, and they think that they can just get away with one-liner. This is egregious. There's not enough adverbs and adjectives to describe what I feel about that, because that's their job. Their job is to provide reasons, and their job is to go one argument by other, one by one, and either debunk it, as the famous term that we use here in the social media setting, defy it, deny it, right, or uphold it, right? But they have to go one by one. That's their job. I know it can be tedious. I know people put a lot of arguments there, but that's their job. That's what we are paid for. So what do you expect if you deny a lower court decision, or of course the trial judges do that as well, right? By one line, that actually absolves you from all responsibility, your job responsibility, right? If you have any other setting, you have another professional that blatantly, violates the most basic expectations from your, salaried position, right? You would be fired on the spot. So, and these judges violate the elementary expectation. It's not about judges. It's about doing your job, right? And if you're not capable, you think it's tedious, you think it's too long to go argument by argument. So please vacate your position and let somebody more professional take it. That's what's supposed to be happening, right? So it doesn't provide any or uphold the trust that the public has in the judiciary, right? These online deniers, they assume we trust them. I think the trust is long gone. I think the trust in government is long gone, and the trust in judges is long gone, particularly because they think they can get away with that type of the skirting the issue, right? And if you put a cogent argument there, and I would respect the judge who disagrees, but analyze it, refer to it. Don't forget that, don't pretend that as it never happened or was never raised, right? And by the way, judges do it all the time now. And you, Jacob, you highlighted another issue, right? So not only they pretend that argument was not made and they don't have to deal with it, right? They also twist your arguments. I experienced that in federal court. I did the other thing. I think I spoke about that. There's a Judge Ann Donnelly, who is a former state judge. She's now a federal judge, denying sua sponte all my complaints against state judges, right, without even inviting the government or the state to respond. With one exception for which I'm grateful. My court case against McFarland's guard Lavanko is still active, still going, and I hope it will get into a jury trial stage in federal court. So we'll see how that goes. But so for that, there she did her job. But when she denied my first or my second federal case against McFarland, she completely twisted my argument. She took one part, another part, combined them together, and made it look as if I asked for money. I never asked for money. I know that if you ask for money, that's another very easy way for the federal court to get out. So I asked for an injunctive relief or for declaratory relief, right, which I am allowed by law. And also goes back to your point, Matthew, which says, Jacob, I'm sorry, I'm just getting feedback, and I want you to provide your input. But it goes back to your point. So Rooker-Feldman, all these abstention doctrines, right? What are they? They're essentially avenues for the judges not to deal with this huge elephant, dinosaur, whatever monster in the room, right? Which is family court. And these are doctrines. What is a doctrine? Doctrine is not a law, and it's something the judges develop. Isn't their job to interpret the law, not to invent the law, right? Which is judicial immunity is exactly that, right? So they invented judicial immunity. They invented all these doctrines, and what we are left with, we are left with complete tyranny of state courts, in particular family courts, right? And nobody can help us, right? And they all know what's going on. I think pro-litigants are filing now federal cases. You are in Colorado, I'm in New York. Matthew, you filed your case in California, right? We had a guest on the show with the case from Georgia, right? So people are filing. Texas is very active. I see that Viridiana. Thank you for joining. The people are bringing it up to the federal court, but they sidestep the issue. How, right? They pretend it's not a civil rights violation. They pretend it's not under color of law, right? They pretend it's not U.S. 42 U.S.C. 1983, right? They pretend, oh no, you are trying to attack, you lost in state court. That's not the case. They twist the words, and if they cannot twist, right, they just ignore the arguments. This is a full insanity. And I quoted the United States case law, right, the Rita versus United States. But truth be told, even that case is very vague. Even that language is very vague, right? What are they saying? Okay, so there's a duty to provide arguments, and the court, the public will trust the courts more if they provide it. That's not enough. There has to be a statement by judges that your failure to answer every argument that any litigant makes, right, is inconsistent, is incompatible with your job as a judge. These judges have to be removed. And bottom line, given all the picture that we have here, right, we are facing judicial tyranny. And then that's just another cycle of governmental tyranny. This time they learn the lessons and they execute it through the courts. Because the general public who is not engaged, they think, oh, you go to court, you'll meet a fair judge like you see in Hollywood. Oh yeah, he listens to that, and they look all imposed and respectful, but they ignore the arguments. They do whatever they want, right? And until you are inside, you don't realize that's the case. So I can go on and on. I think the duty to give arguments, to provide arguments, is fundamental. That's one of the topics that we need to to discuss. Actually, there's another case that maybe I'll post it in the comments. I don't have the exact quotation right now, but when Supreme Court reviews decisions of administrative bodies, right, like SEC, for example, or other bodies of the government that belong to the executive branch, they're much more forceful. Oh, you need to provide arguments, and if there's no arguments, your decision is presumed to be arbitrary, right? But they don't apply to the same standard when it comes to courts. Why? Because the courts need to preserve their absolute power to do whatever they want. This is dictatorship, just covered in what looks like a serious, marble-based buildings. So that's my rant. But this topic is very, very close to my heart. The fact that judges do not provide arguments, that's the crux of the catastrophe that we are facing. Jacob, you wanna?
Well, I have to say also there was. I just want to add one thing in the Reichstag, the old Reichstag, it had marble on the floors also. I just wanted to throw that out there for whatever kind of synchronistic coincidence it may be, but
nothing is a coincidence. These people learn from history, unlike the general population, it seems.
So to your point, Roman, for example, in my objections I just filed last night, if anybody would take the time to actually go read through them and see what I outlined point by point by point, and just a few of the frauds that they used. But they'll take, for example, a small sentence from the background section that made a comment about how my ex-wife was interfering with my parenting time years ago, in terms of a background, a statement about background fact, and then they bring it in and quote it in a way that all of a sudden they're saying, well, you're asking me to interfere in a domestic relations case. And It's so absurd. It's beyond absurd. Any reasonable person, any normal, objective observer, average person, even a lay person in the law, nobody, a regular person would see that this is just completely outrageous. To take a quote from here and a quote from here, completely ignore all the real facts and the arguments, and just say, "Oh, we don't have jurisdiction. We're dismissing it on Younger abstention or Rooker-Feldman." To your point, Matthew, regarding this finality business, they also like to call plaintiffs, state court losers, which that actually triggers me when I hear them say state court loser. That's like one of those. It's almost like getting a court order in the in the email, like you were talking about earlier at the beginning of the show. It's so triggering to hear them try to call you a state court loser. But there's recent case law that explains that you're not a state court loser unless you have taken your state case all the way up to the Supreme Court, and they have basically affirmed the decision, or they've ruled on the decision, and there's finality to that decision. And they also say you need to say whether or not you've exhausted all avenues in the state court system. Anyway, this idea of state court loser business is they just use it to trigger you, to just dismiss you, and to sweep you under the rug and act like you're just upset that you lost in state court. No, we are victims of injustice. We have had our rights violated. We've been trampled on. Our kids have been abused. Our families are suffering. Our families have been victimized. And you just sit back there and cherry pick a few statements from the background section or from this section or that section and pretend that you don't have jurisdiction because you don't want to touch it with a 10-foot pole, because that what's really going on. And they've made a mockery of the judicial system, of the justice system. It's all designed to basically benefit the various, like Roman always says, tentacles of the state or tentacles of the government, whether it's federal or state, it doesn't matter. They're all there to protect each other and to sweep this massive family holocaust under the rug.
This is absolutely right. This is, unfortunately, that's the reality. As long as you have the freedom of speech, which is being trampled on and encircled, like all the freedoms, we lost our jury trial, right to jury trial, which is twice in the Constitution, the 6th and 7th Amendment. That's my favorite topic, and nobody will convince me that if you are supposed to have a jury trial over $20 issue, right? You're not supposed to have a jury trial when your kid is being taken away. This is just insane, right? And the founding fathers, knew that the government will come through the courts, right? So they protected in the civil courts, they protected us in the criminal courts. But then the government was very clever, and they created family courts, which is not mentioned. Tomorrow they will create NASA courts, right? Star space, or whatever, Stargate courts, whatever they call them, right? For astronomers, or and then okay, that's not mentioned in the Constitution, so the Constitution doesn't apply. This is all plausible deniability. It's all clown show, and they think people don't understand. No, everybody understands it. We're peaceful. Nobody calls for violence, but it's our peaceful right to expose it all and to show that there's a deception going on at every level, including the courts and the judges, and we have two jurists here on the show, and we have another de facto jurist who developed the knowledge, right? We understand exactly. We can read the case law, we can read the Constitution, we can read your laws, we can write no less eloquently than you. So we understand exactly what's going on. By the way, there's one topic that I had a note here, right? When you say Matthew, to just tie it all together, when you read the decision, people skim through that. I'm guilty of that, right? I know the bottom line. Okay, I know they denied me again, so I just skim through that. But when you muster the courage, right, and you read through the case, you can actually discover very interesting things, because they lie and twist. And moreover, with the development of AI, double check all the references that these judges, because the judges rely, and the level of judges in family court is abysmal. It's unbelievable, people who get appointed there, right? And they also rely on the court attorneys who also come there, like the case that I exposed, Bondad and Sukaina Sorori and McFarland, right? They're all just one big group of in the case State Line of females, who promote. They think they promote women's rights by doing that injustice. So anyway, so you need to double check. Okay, I'm not saying in that particular case I'll reserve my statement there, but just double check, because many cases that actually don't exist or are twisted or taken out of the context, right? and artificial intelligence. There was a huge scandal, 2 scandals recently that I followed in federal court when lawyers submitted papers with non-existent case law. So we all need to be cognizant of that and actually check, right? Once you go through that initial dread. We are at the top of the, actually, we passed the deadline that I have, so we'll have to wrap up. But I found the reference that I want to just keep here preserved for posterity. There's another very good case that I quote just to show the hypocrisy exhibited by the Supreme Court of the United States. So, and I know that it might be disappointing for some people to show, but we need to face reality. The system is corrupt. The system is not there. Hopefully, they can remedy themselves, right? But as of now, everybody, the federal system knows exactly what's going on, and they just cover for the state system. So the case that I'm referring to is Encino Motorcars LLC versus Navarro, and the exact quotation is 579 US. It's a case from 2016, and that's where the Supreme Court of the United States adjudicated a case against an administrative body of the government, right? And that's what they said. I'll just give the just reach out to me, or maybe I'll post it. One of the basic procedural requirements of administrative rulemaking is that an agency must give adequate reasons for its decisions, right? And then at the end of this quote, they're saying, the quote that I use, but where the agency has failed to provide even that minimal level of analysis, its action is arbitrary and capricious, and so cannot carry the force of law. So if that's the case, if an administrative agency, right, as reviewed by the highest federal court in the United States, is failing to provide the minimal standard of giving the arguments behind its decision, right? It's considered by the United States Supreme Court as capricious, arbitrary, and cannot carry the force of law. Why the same standard doesn't apply to the state courts? There's no reason, right? They're essentially another arm of the same mafia, of the same government, right? So you need to approach them as well with the same standard. They're not doing that because they're judges, right? And we have a class interest of judges who protect each other. That's what's going on, right? So we have an untouchable layer in our government that they just cover for each other. They are not held accountable. The word judges, judicial officer, is mentioned in the U.S. code, in the statute that we refer to, right? And they still say the judges are immune. Like, what insanity is this? But we can go on and on. So I just wanna pull on the screen again. Derek provided comments. So Derek, thanks for watching. We have great audience participation. And then Brad is saying, you guys, that's a good thing that you're doing what is needed to expose this judicial abuse. Keep up the good work. That's what we need to do. That's the only way out. We need to continue exposing. And he's complimenting us again. So thank you, Brad, for watching. Brad had his case in New York as well. I want to finish with the words from Orlando Marquez. Have a good night. I'm needing to step away from my devices for a few hours. So good discussion. So I think you all need. Matthew, you wanna have the last word?
Well, I just want to say it was a terrific show, and I wanted to thank Jacob once again and Roman. It was terrific. You gentlemen are the best.
Thank you, Jacob.
Thank you. It's always an honor to be on your show. I appreciate the inspiration and the encouragement to be more public and to expose what's really going on. I never really, imagined having to be on shows talking about this or filing federal lawsuits, but this is really the only avenue to make any substantive change. I've learned over the years that this is, what you're doing, Roman, and what you're doing, T. Matthew Phillips. It's crucial, and so I'm happy to join in this endeavor to expose what's really going on out there. Thank you.
Thank you very much. Thanks, everybody. Thanks for joining. Thanks for commenting, and please share. Please come next week. And I think we'll finish here. Thank you.